The Tom Woods Show, episode 787.
Prepare to set fire to the index card of allowable opinion. Your daily dose of liberty education starts here. The Tom Woods Show.
Folks, just about everyone would like to earn an additional income stream or even their entire income online. Well, I've been doing it for years and years, and I can teach you exactly what I do. I can show you all different ways to monetize a website, whether linking to affiliate products that are related to what you talk about, or starting your own podcast, or self-publishing a book, or blogging. I can take you step by step through all of it in my free ebook, 5 Paths to an Online Income. Check it out at pathstoincome.com or text the word PROSPER to the number 44222. Hey everybody, Tom Woods here, talking to Bill Watkins today. He is the author of a really, really tremendous book on the Virginia and Kentucky resolutions of 1798 that he wrote probably, 15 years ago, quite a while ago. But he's got a brand new book called Crossroads for Liberty, Recovering the Anti-Federalist Values of America's First Constitution. And that's the kind of topic that interests me as a historian. So I thought, let's get Bill on here. He's a hero for doing that great book, Reclaiming the American Revolution, on the Virginia and Kentucky resolutions. Let's have him come on and talk about his brand new book, Crossroads for Liberty. Bill's a research fellow at the Independent Institute over at independent.org. He's a former law clerk to Judge William B. Traxler, Jr. of the U.S. Court of Appeals for the Fourth Circuit. He's served as a prosecutor and defense lawyer, has practiced in various state and federal courts. He's written scholarly articles for many, many publications and popular articles for many more still. And he's the author of several other books. But today, our focus is on Crossroads for Liberty. Bill, welcome to the show.
Tom, it is great to be with you. Thank you for having me.
It's been, over 780 episodes. I'm finally having you on. I should have talked to you a long time ago. I mean, you wrote one of the only books out there on the Virginia and Kentucky resolutions of 1798. That is a big, big deal. So
at the time, no one else had touched that issue, but since that time, you and Kevin and others have done great work on the nullification issue, and my hat's off to you.
Oh, thanks a lot. But you really blazed the trail for us, and I appreciate that. So let's talk about your new book, which I was just mentioning in the intro, Crossroads for Liberty. Subtitle is Recovering the Anti-Federalist Values of America's First Constitution. Can you just explain your subtitle?
Sure. What I'm trying to get at with the subtitle is, in the American political tradition, we've forgotten the Anti-Federalists. We pushed them in the dustbin of history. They're losers. We love winners in America. But the principles that they articulated were not losing principles. They're central principles to any sort of true Republican government. Of course, Republican with a little R there. And for America, if we want to make any progress back toward a tradition of limited government, self-government, we need to study the Anti-Federalists.
So let's go ahead and do that. In your book, you go through, if somebody were to look at the table of contents, he'd see all the major kinds of topics that we would associate with the Constitution. So things like the regulation of commerce, the necessary and proper clause, standing armies, the commander-in-chief, the judiciary, all these sorts of things. But you also start off with a little history of how we got there. And there's some discussion of the Articles of Confederation, the movement toward the Philadelphia Convention, and so on. Do you have any kind words for the Articles of Confederation, or do you hold the civics class view that, of course, it had no merit and it was stupid and backward and we're well rid of it?
The Articles of Confederation, as I try to show in this book, of course, was our first national constitution, and it was a beautiful constitution. It was a successful constitution. Of course, the two main goals of the Articles was to unite the colonies in a league so we could defeat Great Britain and each state could be independent, and also to preserve self-government in each individual state. Obviously, we weren't fighting the British in order to establish some great central government in Washington, D.C., New York, or elsewhere, but rather to govern ourselves in our state and local assemblies. If you look at those two main goals of the Articles of Confederation, we achieved it under the Articles. They were a success story. States governed themselves. The people governed themselves in their local affairs. We were banded together nationally with the Confederation for much as defense, but really not much else. And it worked. These were beautiful, strong principles of true Republican government that are traceable to the Declaration of Independence and unfortunately were later abandoned with the Constitution of the United States.
What about the standard complaints about the Articles, that it was too weak and therefore the government was feeble, couldn't carry out foreign policy, it couldn't get enough revenue to function properly, it was neglected, it was inefficient? I mean, as I describe all these things, most of them sound pretty good to me, but what would you say to that? Because that is what you're going to read in a high school textbook.
No, you're right about that, and I try to be honest in the book, too. Were there problems with the Articles? Sure. Could they have been fixed is the real question without a whole-scale abandonment of the Articles of Confederation. I argue that they absolutely could have. You know, I think most telling is Thomas Jefferson's reaction when he first saw the proposed Constitution. Of course, Jefferson was in Paris at the time, serving as the American minister. And his initial reaction was, we should have preserved the venerable fabric, was his term, of the Articles of Confederation and perhaps added 2 or 3 additional articles to secure a more perfect government. Yes, Jefferson realized there were some additions needed, some changes that needed to be made. I completely agree with him, but they were not to the degree that we needed to abandon a system that had worked very well in accomplishing its main goals.
What do you make of the thesis that we sometimes hear from libertarians and from some traditionalist conservatives that what happened in Philadelphia was not a wonderful meeting of world historic geniuses who produced a wonderful document for the ages, but to the contrary, that this was a coup of sorts, whereby the decentralism of the old system was overthrown and replaced by a more centralized nationalistic kind of system? Do you have any sympathy for that argument?
You know, I originally, when I approached this issue in my constitutional studies, I wanted to put the Constitution in the great pantheon of American charters, that what a wonderful work of the framers. But yes, I have a whole lot of sympathy with that position now that I have studied the AntiFederalists, their writings. I think Mr. Guttman's work on Madison and what Madison's intentions were at Philadelphia to essentially destroy state power, to have some national veto over all state legislation. What they set out to do at Philadelphia was not to simply improve on the model that the Articles had established or that the Declaration had declared, but rather I do think it was a whole-scale change, and I think it was seen by the Anti-Federalists. Yes, there was much abuse of interpretation among the Hamiltonians and George Washington and others in the 1790s. Granted, there was abuse, but the Anti-Federalists saw it coming. They predicted it. And no one can deny that I think this was a coup against true Republican principles.
All right. So if that's your position, then how are you able to sustain the thesis that the Constitution has anti-federalist roots or themes running through it?
I would say that the Constitution, the anti-federalist themes that we see in American history were offered by the Anti-Federalists in the ratification debates. They were offered afterwards as amendments to the Constitution that Madison overlooked and that he ignored. There was a great opportunity for structural change to the Constitution after it was ratified. Some of the greatest minds in the Republic offered amendments to many clauses, from the taxing clause to the representation, to the enumerated powers, etc. But those were ignored. I think to our poverty, they were ignored, that we have to recover these anti-federalist values, I argue in my subtitle, from our first Constitution, which in my view is the Articles of Confederation, not our second one, which is the Constitution of 1787.
All right, let's talk about then. Let's talk about a few of the more common clauses that people run into, and I've talked about these at some length. And I'm thinking in particular of the General Welfare Clause, the Necessary and Proper Clause, and the Commerce Clause, and the regulation of these things. So, what can you say about the regulation of commerce? Because that's the one that comes up in all the Supreme Court hearings, right, for where Supreme Court nominees are brought before U.S. senators. What's the correct way to think about that?
Well, I think the correct way to think about commerce is if we look at the document, we look at the debates, what they had in mind was deep water shipping, if you will. They had in mind, now we can disagree whether trade regulations, a navigation act, if you will, is in the best interest of the country. We can argue that have free trade and our people would be better off no matter what Britain, France, or another country does. But that's what they were aiming at with the Commerce Clause. Britain, after the American Revolution, we lost a lot of trade because of their navigation acts, that we were no longer under their protection. We needed, in the framers' view, to be able to retaliate, have our own navigation act to regulate this deep water shipping. That was the purpose of it. What it has become today, if you look at the federal code, for example, laws that criminalize possession of child pornography, child porn, bad thing, not defending it. But where do we find anything about that in our Constitution that would grant a police power for Congress to criminalize that, for example? Well, the Commerce Clause, because perhaps a CD or a video moved in interstate commerce, either the internet or the mails, and therefore Congress claims the power to regulate that. Our civil rights legislation, we all know that Ollie's Barbecue and other targets of civil rights legislation were regulated by Congress because, say, the ketchup they used traveled across state lines. So the Commerce Clause has now become a method that the federal government uses to regulate any and all activity that could substantially affect, could possibly affect the national market for a good. It was not seen that way by the framers of the Constitution. I will give them credit. There has been abuse of the interpretation. But George Mason, for example, in his anti-federalist writings and at the Philadelphia Convention, realized that this would be an enormous power. It would be susceptible to abuse. And he suggested that before Congress could pass commercial regulations, we should have a 2/3 vote rather than a mere majority. Considering how the Commerce Clause is used today, I think Mason made a great point.
Let's talk about the judiciary, actually, for a minute, because given that we've just had a presidential election and given the role the court plays in our national life these days and the significance of a presidential election in the sort of the character of the justices we can expect over the next 4 years, maybe it's an opportune moment to go back and look at what the role of the judiciary was supposed to be in our national life.
Right. Well, of course, under the Articles, it was a very limited judiciary. Essentially, Congress established courts to hear maritime cases, admiralty cases, as well as they could pick judges and set up a panel of judges to hear state boundary disputes if the state so desired. Very limited judicial functions. The state courts were to be the main courts in that union. Of course, even with the Constitution of 1787, we were not required to have a federal judiciary. All that was required under the Constitution at its base is one Supreme Court with one judge, a Chief Justice. Many of the anti-federalists and other more Republican-minded individuals argued that Congress should not set up a federal judiciary of trial courts and appellate courts, but rather that those state courts should serve as our main trial courts for the Union with a possible appeal to the Supreme Court. Of course, the Federalists, once in power, completely abandoned any illusions of that and set up an elaborate federal court system. And now we have a Supreme Court that essentially claims to be the final word on all matters of constitutional interpretation, though I argue in this book, as well as another book I wrote called Judicial Monarchs, that even John Marshall did not intend that in Marbury versus Madison, that the Marbury opinion, rather than establishing the Supreme Court as the ultimate arbiter of the Constitution, merely established the court as a co-equal branch that could make reference to the Constitution just like the other branches. It would not be supreme, but it would have an equal say, and that would fit in with the Jeffersonian idea of departmentalism. Of course, that's long gone, and now we have essentially a Supreme Court that makes policy for the nation. Look at the marriage decision, look at affirmative action decisions and other things like that, and it is a very political branch.
Can you think of anything in the Constitution that has been, in practice anyway, forget about its original intent, but in practice, really bad for the cause of liberty that most of us may overlook? Like, is there a verbal time bomb in there that a lot of people might overlook?
Well, I think if you look at the Constitution, one thing that still frightens me to this day is the treaty power of the Constitution, because treaties at one time were simply bilateral agreements among nations, ceasing hostilities, perhaps a treaty of commerce, an alliance, something like that. Whereas now the treaty power today has become a mechanism where countries agree to all these, say, for lack of a better term, human rights agreements, that they agree to pass certain domestic legislation in accordance with these treaties. The Constitution makes treaties the supreme law of the land, and the Supreme Court, back in Missouri versus Holland, the migratory bird case back in, I believe it was 1916, essentially held that, sure, Congress or the Senate and the President can enter into a treaty with a foreign power, and even if the terms of that treaty exceed Congress's power under the Constitution, that's okay. That's dangerous. That is, to me, a poison pill that could destroy constitutional government in toto.
But are there any plausible scenarios in which the treaty power could really be used in a way that would harm average Americans? The migratory birds thing is a little bit obscure, even though I know that that's just where the principle comes in. But how could this be used in a way that we would really feel it and we would really say, boy, Watkins was right?
Sure, there are a lot of examples. There have been some more radical groups that have taken the position, for example, that affirmative action, rather than a state policy decision or a national policy decision, is actually mandated and required by international obligations that we've entered into through the treaty power. Now, granted, that has not gotten any traction yet, because the Supreme Court of the United States has been very capable of pushing the affirmative action envelope for admissions to colleges and employment and other things. But that is one example where radical groups have argued that, yes, our treaties, these international agreements, not treaties in the old sense, but technically they are, would mandate policy results consistent with what we've signed and what these international bodies might dictate.
Kevin Guttman, whom you mentioned earlier, basically offers the following argument. He says, here's what happened with the Constitution. You did have people who wanted a nationalist model for the U.S. who were at the convention. That's what they wanted to see happen. But when the document was sent around to the ratifying conventions and explained to the people, it was explained in an anti-nationalist, more of a compact or federalist view with a lowercase f, that is a decentralist kind of way. And he says that what matters about the Constitution is not so much what particular clauses taken out of context might mean, but how were these things explained to the people? And he says somebody like James Madison was an honorable figure in this whole process, because although Madison did want a nationalist approach, as we can see from his original plan. When he saw that that's not what he got and that that's not how the document was sold to the public, he didn't try to pretend that that's what the Constitution was. And so in the 1790s, he advocated what he believed, he stood in defense of the decentralist Constitution that he understood the people had gotten. Whereas Hamilton knew the people had gotten a decentralist Constitution, but then acted as if the nationalists had been victorious and then went ahead and interpreted it accordingly. So that's how I deal with the people who say the whole thing was a coup. I would say, yeah, there were people who wanted to do that, but the end result was a document that was sold to people as being just a small modification of the Articles that basically still kept the states as the priorities and so on and so forth. Do you have any objection to that way of looking at it?
I don't necessarily have an objection. Kevin's work is just tremendous in this area. I do think that he and Madison and Jefferson argued this in the 1790s, that in interpreting the document, it ought to be interpreted in accordance with what its friends, meaning the Federalists, capital F, I guess in that case, told the people, this is what you're getting. They urged that interpretation. However, as a lawyer, I can tell you that very often the bottom line comes down to the text. It's nice to be able to say, this is what we intended. Here is evidence of the original intent. In the Federalist Papers, debates, Eliot's debates and other places for the convention. But very often it comes down to the text, and the Anti-Federalists predicted how the text would itself be abused. Now, in fairness, do I think that Hamilton and others should have upheld their bargain, if you will, with the people? They presented the Constitution as a limited national document. Should they have upheld their end of the bargain? Yes, they should have. Did they ignore their previous words as soon as they came to power? Absolutely. And Madison, to his credit, we see him in his report in Virginia with the Kentucky and Virginia Resolution crisis, as well as he's the architect of the Virginia Resolution, came down with positions more consistent with what the people were sold in the late 1700s.
What do you think about the amendment process when it comes to there are two ways to amend the Constitution, and one of them is the way that we've used every single time, which involves the Congress. But there's another way that does not involve the Congress, and that is the Amendments Convention, the Article 5 Convention process. And the thinking behind that is that, as Kevin puts it, if Congress is the source of your problems, it's not going to be the source of your solutions. So it may be that at some point you would need to have recourse to a solution that does not involve Congress, namely the Article 5 approach. Now, I'm just curious to know, just for the heck of it, what your opinion on that is, because that's been coming up lately as a last resort because nobody else knows what to do.
Now, Kevin makes a good point there, and I address this in the book, that unfortunately, in the dying hours of the Philadelphia Convention, it was decided to leave the amendment process ultimately in the hands of Congress. Because even with the convention method that you mentioned, Congress is the one who has to summon a convention, and one could argue that Congress can set the bounds for the terms of the convention, etc. What we need, I think, and I think it was just lost there at the very end, is an amendment procedure where the states themselves can propose amendments and vote on amendments and ratify amendments without congressional action. That, say, South Carolina could propose a balanced budget amendment, if that were a good thing. And other states, to the extent you get the requisite 2/3 of other states in either convention or in the legislature that agree to that amendment that was put forward, it becomes part of the Constitution without any congressional mediation there. I think Gouverneur Morris and others there at the very end of the convention torpedoed a system where the states would have had a voice, but everyone was tired, ready to go home. And unfortunately, the dangerousness of leaving Congress with so much power was overlooked, I think, by Madison and others.
If we may, let's talk about your section on the commander-in-chief, because, again, we've just had this election, and, oh gosh, all through the election season, you get lectures about so-and-so being a fit or an unfit commander-in-chief over and over. So what does it mean for the president to be the commander-in-chief?
Well, the Anti-Federalists, based on the way the document was worded, accused the drafters of creating a generalissimo, an all-powerful figure that would drag the United States into foreign wars, etc., would see his glory, his legacy, as based as a leader of armies and a very dangerous person there. Of course, the Federalists argued, well, hold on a minute. It's the Congress that declares war. It's not as with the British system where the king can drag the nation into his affairs and to fight battles across the channel and here and there. We have a different system. Of course, it is proven in time that Congress, for its own reasons, has abdicated this war-making power. It's abdicated really its role in foreign affairs generally and ceded that to a president. Presidents might go and get an authorization for military force, which Congress leaves pretty open-ended, where indeed we do have a generalissimo. Granted, I think Jefferson was correct when he declared upon taking the Oval Office that he was merely the chief executive of the United States. His job was to execute duly enacted laws passed by the Congress. Today, we have elevated this to some sort of Caesar figure who does not merely execute but proposes, uses executive orders to create a whole new field of legislation. And of course, administrative law now with the agencies and the president appointing the heads of the agencies, he's a tremendously powerful individual. Then it was certainly not intended, I don't think, by Madison and others to make him that powerful. The Anti-Federalists saw a danger, but they didn't see the full danger that the modern regulatory state would present for a president to make law.
What do you think needs to be done now? Or let's suppose you don't have to worry about practicality or persuading a million people. If you could make some changes constitutionally, what do you think should be done?
Well, here's what I think should be done. I think, one, we should have a discussion. Frankly, is the United States too big to be free? This whole issue of scale, Tom, are we simply too big to be a free republic? I think that's a fundamental question that was debated by the Federalists and Anti-Federalists. Of course, the Anti-Federalists, looking at Montesquieu, believed that a large continental republic would be inimical to liberty. When we look at debates regarding representation, today, as I point out in the book, the average congressional district is one representative for about 750,000 people. Washington at the Philadelphia Convention had in mind, he thought one for every 30,000 was about the maximum number that you should have to be able to maintain Republican government. I think a fundamental question is, are we too big to be free? Do we need to expand the House if we can maintain Republican government? What would that look like? I think we see in Germany, Japan, Great Britain, and other countries, they have much better ratios of representatives to citizens than we do. We have artificially capped the House of Representatives for well over 100 years at its current number. Question, should we expand the House, make it more representative so the people would have a voice? That's one thing I think we should consider, is expanding the House. Another thing I think we should consider is borrowing and spending. The Anti-Federalists wanted a provision in the Constitution that required a supermajority before the government could take on debt to finance wars or whatever sort of government programs. I look back at some of those proposals and think they could be adopted whole cloth today. This would give the few fiscally responsible representatives and senators that we have, those of the old Ron Paul school. I know Dr. No was often alone in his protestations, but there are a few up there that are sympathetic. That would give them some sort of stick, some sort of weapon to beat back all this spending, especially when we're not taxing ourselves for it. Not that I'm a fan of high tax rates, but as Jefferson and Madison noted with the Kentucky and Virginia resolutions, when John Adams started raising taxes for his war with France, they said, well, this is good news because war fever will be broken under the guise of the tax gatherer. People would feel that burden. But of course, when you're just borrowing money and running up a debt, that effect is lessened there. So I believe that amendment that the Anti-Federalists propose would be a good idea for us to adopt there to cut back on that spending. I also believe firmly that if we're going to accept a country in which the Supreme Court does policy, that they make policy judgments, whether it be about who should be able to marry or who should be able to get into what schools, whether, say, juveniles should be subject to capital punishment, policy decisions. Well, doggone it, they ought to be elected. The people are the ultimate sovereigns in this country, and the courts, the Congress, the president, they're merely agents of the people. The people should have some say in who it sits on the court. If it's going to be a policy-making body, let it be accountable to the people.
Well, the book is Crossroads for Liberty, Recovering the Anti-Federalist Values of America's First Constitution, and I'm linking to it at tomwoods.com/787. Well, best of luck with the book, Bill. I'm glad you did it. It's very interesting. It's packed with citations and great historical information of the kind nobody learns in school. That's the kind of book I feature on this show. Thanks so much.
Tom, thank you for all you do for the liberty movement.
Okay, tomwoods.com/787, remember, is where you can get Bill's book. There's a nice Amazon link there to get Bill's book. And also, I want to tell you about a brand new site called, I love this, truthjab.com, created by a listener of this show. Truthjab.com. Here's the About page. TruthJab is all about economics, political theory, current events, and theology from a Reformed Christian and libertarian, parentheses, usually overlapping, perspective. TruthJab seeks to present these topics to you like a quick punch to the face. I love that. So truthjab.com. And if you go there, you can see he's just getting started. He's already got numerous posts up about all sorts of things that are of interest to us, like the various people who are being bandied about as possible appointees in a Trump administration, all the sorts of topics you'd be interested in and that we cover here on the show. Well, you're going to get them like a quick punch to the face over at truthjab.com. So support a listener of the Tom Woods Show by checking out truthjab.com. I will link to it at tomwoods.com/787. And remember, of course, he's getting this nice shout-out because he used my link when he got his web hosting. So he gets the shout-out, he gets the nice backlink on my site, the 24 video tutorials, and membership in my private bloggers group where we plot and where we help each other out. It's a great and glorious thing to be part of. If you're interested in any of this, you want to get those bonuses, then before you get started on your site, check out tomwoods.com/publicity. Tomorrow, well, you know what? I don't want to tell you what tomorrow is. Tomorrow, be open-minded. Tomorrow, when it comes to episode 788, there are some of you who will say, nope, I'm just not going to listen to an episode on that subject. And no, it's not music. I'm not going to deal with progressive rock for a little while. I'm going to get Berzer on before the end of the year. It's not that. But some of you, I think, are like me and think, well, I'm not so sure I'm not an aficionado of this, so therefore I won't listen to the episode. Listen to it, and then you're going to feel bad for not having listened to the other ones. That's all I'm going to say about episode 788, which you will love, and which is coming up tomorrow. See you then.
Become a smarter libertarian in just 30 minutes a day. Visit tomwoods.com to subscribe to the show for free, and we'll see you next time.